Straight ahead on Law and Crime Daily. Kim Potter's fate now in the hands of the jury. We head to Minnesota for the latest on deliberations and the signals the jury is sending in the former police officer's manslaughter trial. And was the Jussie Smollett investigation mishandled? We take a look at the special prosecutor's scathing report. Plus, new information in the Pike County massacre.
That according to Jake Wagner, George did not shoot or kill anybody.
Does that mean George Wagner IV should be spared the death penalty? And later, the federal sex crimes trial of Ghislaine Maxwell. Law and Crime Network's Adam Klasfeld is at the courthouse with the latest on deliberations. Law and Crime Daily covering court cases from coast to coast. Welcome to Law and Crime Daily. I'm Anjanette Levy, in for Brian Buckmeyer, and with me in New York is Terry Austin. We begin with day 3 of jury deliberations in the trial of former police officer Kim Potter. This is all unfolding in Minnesota. Potter, as you may recall, faces charges of first and second degree manslaughter stemming from the shooting death of Daunte Wright during a traffic stop in April. Potter, that is, and an officer in training pulled Wright over for an expired tag. When they determined he had a warrant for a weapons charge, they attempted to take him into custody. Body camera footage shows the struggle and Wright trying to take off. Potter yelled, "Taser, taser, taser," but shot Wright in the chest with her gun. Wright's car sped away and crashed, and he died. Deliberations began on Monday, and on Tuesday, jurors indicated they could be deadlocked with a question they posed to the judge.
Members of the jury, you submitted 2 questions for me. The first question is, if the jury cannot reach consensus, what is the guidance around how long and what steps should be taken? And the answer is, I'm going to reread to you an instruction that I previously gave you. You should discuss the case with one another and deliberate with a view toward reaching agreement if you can do so without violating your individual judgment. You should decide the case for yourself, but only after you have discussed the case with your fellow jurors and have carefully considered their views. You should not hesitate to re-examine your views and change your opinion if you become convinced they are erroneous, but you should not surrender your honest opinion simply because other jurors disagree or merely to reach a verdict.
And with Terry and I today is Philip Dubé. He is a deputy public defender in Los Angeles County, but he is not here in his official capacity. He is here in his personal capacity to offer his insight and his expertise. So, Philip, thanks for joining us. I'll start with you. The jurors also asked the judge whether or not they could see the firearm that Kim Potter was carrying without the zip ties that kept it in the box. So that coupled with the question about not reaching a consensus, as a defense attorney, how do you see that?
Oh, I'm smiling. As to the gun, that's a very serious question that the jury has. And by the way, it might just be 1 or 2 jurors that want to know. Keep in mind that when Kim Potter approached Daunte Wright, both of her weapons, namely the taser and the service revolver, were resting in a holster. So the only thing she really had physical access to was the handle. So the jury's probably going to want to see if she could tell by the feel, the contours, the design, the weight, if somehow the handles of both of those items could be easily confused, as opposed to seeing them both removed and looking at the different colors and the size and the weight, but whether or not the handle could distinguish them in any way. Regarding the questions that they had regarding unanimity, or what they do if they're deadlocked. Unanimity is only required to convict and to acquit. It is not required to hang the jury. And if you have 1 or 2 lone holdouts, bless their souls from a defense standpoint.
Now, Terry, I'm interested in what you have to say about this. The jury asking for guidance if they can't reach a consensus. Should the prosecution be worried?
Oh, the prosecution is definitely worried because if they're deadlocked, there will be a mistrial, as Philip was mentioning there. And I think it would be a loss for the prosecution. They could bring the charges again, but that would take more time and more resources. So I think that they would probably think twice about doing that. But yeah, so far, I think the prosecution needs to be worried.
Very interesting, and it'll be interesting to see how it all shakes out. We're moving on now to federal court in California, where the fate of Elizabeth Holmes, a former Silicon Valley CEO, is also in the hands of a jury. On Tuesday, jurors asked Judge Edward Davila if they could take the jury instructions home to review them. Judge Davila denied that request, saying all deliberations should take place in the jury room. Jurors heard 15 weeks of testimony with more than 32 witnesses. Holmes faces 2 counts of conspiracy to commit wire fraud and 9 counts of wire fraud for her time with the now-defunct company Theranos. Once touted as a company that would revolutionize blood testing, later testing found that there were many issues with Theranos' Edison testing device. If convicted, Holmes faces the possibility of 20 years in prison and a fine of $250,000 plus restitution. Deliberations will resume Thursday. And in Wisconsin, an accused murderer stands before a judge weeks ahead of his trial. All this in connection to the murder of a prominent Milwaukee attorney. In September 2020, Theodore Edgecombe was riding his bike as Jason Clearman and his wife drove nearby. Edgecombe's defense team says surveillance video shows the car tried to run Edgecombe off of the road. After Clearman got out of the vehicle, Edgecombe shot and killed him. Edgecombe's attorneys claim Clearman lunged first and that he was acting in self-defense. Investigators found and arrested Edgecombe in Kentucky 6 months after the shooting. Edgecombe is charged with homicide, but claims newly released video proves he killed Clearman in self-defense. Law&Crime will have gavel-to-gavel coverage of that trial starting January 3rd, so tune in to the network to follow all of the developments. Well, still ahead on Law&Crime Daily, a plea from one of the family members charged in the Pike County massacre, why he says the death penalty should be dropped, and what the judge decided. But first, a scathing report on the investigation into Jussie Smollett's claims he was the victim of a hate crime. Our experts on what it could mean for the prosecutor. That's next on Law&Crime Daily.
Hi, this is Dan Abrams with exciting news for all of our Law & Crime followers on YouTube. You can now get the live Law & Crime network with YouTubeTV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTubeTV today and then locate Law & Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law & Crime every day with YouTubeTV. We put you in the jury box.
Welcome back to Law&Crime Daily. We have an update for you on the Jussie Smollett case out of Illinois and an investigative report that's come out that says that the state's attorney's office in Cook County mishandled the case. Earlier this month, Smollett was found guilty of felony disorderly conduct for filing a false police report in an alleged attack in 2019. Prosecutors say Smollett made up the hate crime attack for publicity. This week, an investigation into the Cook County State's Attorney's Office was released, revealing misconduct by Kim Foxx and her office. The report says the state's attorney's office lied about several things during the investigation, including Smollett's criminal background. After learning the actor was a suspect in the case, Fox also lied about cutting off contact with Smollett's sister. Initial charges were dropped against Smollett in 2019, but Smollett was later indicted on new charges after a special prosecutor was appointed. Well, Philip Dubé, I'm going to start with you on this one. You know, what should happen to Kim Foxx as a result of this investigation? She is the elected official who's ultimately responsible for all of the actions taken by her office.
Criminally, nothing should happen, Anjanette. In my humble opinion, as the lead prosecutor for an entire county, she has broad discretion under the separation of powers to file, withdraw, seek to dismiss, or not otherwise pursue charges, including the rejection of charges. If the public at large or her electorate is dissatisfied with any decision not to pursue charges, the remedy is the next election. You vote her out.
And Terry, I'm wondering what you think. You know, the special prosecutor, Dan Webbs, found no evidence of criminal misconduct, but the report was incredibly, critical of Kim Foxx. So how can that be reconciled?
Well, on the one hand, Anjanette, the special prosecutor is saying that there's nothing criminal here. But on the other hand, he is saying that the case was mishandled. He's saying that maybe there might have been some ethical breaches. She should have been more forthright. She should have communicated better. And before dropping the charges, I think one of the things the special prosecutor was trying to say is the case should have been handled more ethically and more thoroughly. So basically, her conversations with the Smollett family should not have occurred. And it would have been more advisable, perhaps, if she had recused herself, only because she really does know the family. So that's so that they can avoid the appearance of any sort of conflict. But overall, there's nothing criminal here. She could have possibly handled it slightly better. But basically, as Philip says, they can be voted out if they don't like what happened here. So that possibility does exist.
Yeah, it'll be definitely interesting to see what the voters there in Cook County do the next time she's on the ballot. All right, coming up next on Law and Crime Daily, the federal sex crimes trial of Ghislaine Maxwell. We're going to bring you the very latest from inside the courtroom, plus the latest on the Pike County massacre. Will a judge grant George Wagner's request to avoid the death penalty? That's coming up after this. Welcome back. One of 4 members of a family accused in the murders of 8 members of another family is asking a judge to drop aggravated murder charges against him, along with the possibility of the death penalty. George Wagner IV is accused of conspiring with his younger brother Jake and their parents, Angela and Billy, to murder members of the Roden and Gilly families. Jake and Angela have admitted to their roles and have agreed to testify against George and Billy. If Jake testifies truthfully, the death penalty for his family members will be taken off the table. That's part of the deal he made with prosecutors. Jake Wagner admitted to personally killing 5 of the victims and shooting a 6th in April 2016, so he and his family could have the sole custody of the daughter he had with Hannah Roden. George's attorneys say the aggravated murder charges against him should be dismissed since he didn't shoot anyone.
George Wagner didn't shoot anybody, yet the state is pursuing death. And what is unique to this case is that it has taken death off the table. It has agreed to a life plea for Jake, who killed at least 5 people. That's inherently unfair.
We made the same offer to all 4 co-defendants in this matter, that we would negotiate with them if, in fact, they not only told us what happened that night, but also Jake Wagner led us to physical evidence. He led us to murder weapons that we never had, that was extremely critical to the resolution of this case.
Now, Judge Randy Deering denied the request to dismiss those aggravated murder charges and the death penalty specifications. Wagner's trial is scheduled to begin in April of next year. And let's bring Philip and Terry back in to discuss this. Philip, you're a criminal defense attorney out there in L.A., but in Ohio, just knowing about a crime like this and being present, that means you're legally culpable. But do you think that his attorneys have a point about the death penalty?
Not one point at all. Unfortunately, under Ohio law, if you knowingly conspire, even with the gunman, and you are the non-shooter, you are liable for the aggravated murder, which is a capital offense under Ohio law. And it sounds like this prosecutor offered all the co-conspirators a non-death offer, but it sounds like Wagner Sr. is going for broke because he doesn't want to serve life in prison.
And Terry, I'm wondering, do you think it made any sense for Wagner's attorneys to file this motion? Even though, Jake, it's very clear, if he follows through and he testifies truthfully, the death penalty is off the table for the rest of the family.
Well, that's a great question, Anjanette. What the defense is doing here is hedging their bets. If Jake doesn't follow through with his proffer, now his proffer was the fact that he was the shooter, not George, and he has to basically get on the stand. He has to testify truthfully. And the prosecution has already said that they're willing to drop the death penalty against everyone, not just Jake, but George as well. And she said that she offered that deal to everyone. So it's not unconstitutional, as the defense was trying to say. So I think ultimately that the defense's argument failed here. They were trying to go for broke, and that did not work. They wanted the judge to dismiss all of the charges against them because they're saying that what the prosecution is doing is unfair. But at the end of the day, as you heard, the judge decided ultimately, no, I'm not going to dismiss these charges. And basically, I think if in fact Jake doesn't testify, then the defense for George could always bring that issue back up. But for now, all of the charges are standing against George.
That's for sure. And it'll be ultimately up to the jury to decide. And one interesting point, you know, his attorneys, George's attorneys, wanted Jake to be in court to testify at this hearing, to testify that George didn't shoot anybody. And the judge said, no way, we're not doing that. So just that was an interesting little tidbit that came out of that hearing. All right, when we come back, we're going to move on to the trial of Ghislaine Maxwell in federal court. Law&Crime's Adam Klasfeld is going to bring us a report from the courtroom as deliberations move forward. Welcome back. The jury has ended its deliberations in the federal sex crimes trial of Ghislaine Maxwell for the week without reaching a verdict. Those deliberations will resume after the holiday weekend. Now, the British socialite and former girlfriend of Jeffrey Epstein pleaded not guilty to 6 felony sex crimes charges. Throughout the trial, the jury heard testimony from women who say Maxwell groomed them for Epstein to sexually abuse. Epstein was charged with similar crimes in 2019, but was found dead by suicide in his jail cell before his case went to trial. The prosecution's argument focused on Maxwell's connection to Epstein. Meanwhile, the defense told jurors Maxwell is a scapegoat for the former financier. Deliberations, as I mentioned, will resume next week. And our own Adam Klasfeld has been in the courtroom the entire time throughout this federal trial, and he's been bringing us up to date. So let's listen to a little bit of the latest from Adam Klasfeld.
They are looking for a wide variety of evidence. First, right off the gate, they looked for the transcripts of all of Ghislaine Maxwell's alleged victims. That includes Jane, the first accusing witness, Annie Farmer, the only witness who is testifying against her under her full and real name, and also Carolyn, who is at the nexus of the sex trafficking count. So they wanted the entire transcripts from them. Notably, they did not ask for the transcript of Kate, because it's already been decided by Judge Nathan that Kate was above the age of consent and can't be considered to convict Ghislaine Maxwell based on the alleged acts she described. So they're paying attention right off the gate, those 3 accusing witnesses. The next jury note was very interesting. They asked for notes from an FBI interview with Carolyn in 2007. Now, here's why that's significant. Those notes, generally known as 302s, are not in evidence, and they are unauthenticated records of an FBI interview. They're not a transcript, and the defense throughout the case has told the jury that their stories have changed. And right now, the jury is considering that issue. Has Carolyn's story changed from 2007, according to the notes of that interview, to her testimony this year?
And that was Adam Klasfeld talking about the questions the jurors had for the judge and the evidence they're looking to see. Philip, I'll start with you on this one. I spoke with Adam, and he said the defense appeared to be very happy after hearing those questions from the jurors, that they were smiling. Should they be this happy? Should they be excited about these questions?
Oh, no, we don't count our chickens. It is much too premature. Keep in mind that the jurors are going through multiple counts, and it could be that maybe they're hung up on one count. Miss Maxwell's exposure is 40 to 50 years, so maybe she'll beat one count or hang one count. She's still looking at a boatload of time. It sounds like the jury wants to see the raw notes from the FBI agent who interviewed one of the victims who was put into trafficking years ago. It appears that the contemporaneous notes taken by that FBI agent are inconsistent with what the woman is saying on the stand in front of the jury. Juries don't like it. They want to see the raw, wet notes that were taken contemporaneous to that conversation, to that interview with the woman. And if they don't match, that's reasonable doubt.
Really interesting, and I could get into a whole nother topic about how the FBI does not record these interviews with audio or video, but I digress. That's a topic for another day. I think they should be doing that. But Terry, we're getting some late word now that they have requested, the jury actually requested the transcripts from Kate, another one of the accusers. So they have requested now the transcripts from all 4 accusers. What do you make of that? What's the significance?
Wow, that's interesting. I was going to say that I thought they didn't ask for Kate because the other 3 were younger. And as Adam mentioned, we shouldn't consider Kate really as a victim because she was 17 at the time. 2 of them were 14 and 1 was 16. But I also think that they weren't going to ask for Kate because she seemed to be the most credible to me. There weren't that many inconsistencies. She also admitted some things like the fact that Maxwell and Epstein did not like the use of drugs, so she never did drugs around them. And that was saying basically that they were, good people. They didn't like the use of drugs. So now that they've called for it, I think they are considering all of the evidence. They want to make sure they know everything that happened.
All right. Well, Phillips, thanks for joining us today. We appreciate it. And thank you for joining us on this edition of Law and Crime Daily. We'll see you next time as we discuss justice in America.